Good afternoon again, ladies and gentlemen. Seems like we did this yesterday, but I won't be nearly as long this time. I'm back, as I promised you I'd come back, to try and wrap up the defense discussion of the evidence with you. You just heard what I believe was a remarkable discussion by Mr. Barishek, an excellent lawyer. He may be from Brooklyn, but he's become a Californian as far as we're concerned. He is a very valued member of our team of defense lawyers for Mr. O.J. Simpson. And you see why. This is indeed a talented lawyer. And so he shared with you a number of things which I will not be redundant about and go over. You have them clear in mind. And if I were not to say anything else, there are many reasonable doubts in this case, and O.J. Simpson is entitled to an acquittal based on what we have told you. This is my last chance, of course, to speak to you, and I want to take this time to tell you again that the prosecution, because they bear the burden of proving this case beyond a reasonable doubt, will have the opportunity to speak to you last. We may not be here too late tonight because I'm not going to be much longer, and I think that more than likely, I think we can probably guarantee this case is going to get to you sometime tomorrow afternoon, so you can kind of sit back and relax. It's been a long, long, long road to get to this point. It's been kind of like a relay race, hasn't it been, in many respects, in this journey toward justice. The prosecution was first running with it. We then took the baton and we started running with it. We've run almost up to the jury box. And soon, we're going to pass the baton to you. This is how our system works. This is what makes it so great. We pass the baton to you, and we'll be glad we can then sit back and watch you at work. You watched us for a year, 2 or 3 days. Now we get to watch you. It'll be symbolically watching you because we won't see you back in that room, but you know we're going to be counting on you, giving both sides the benefit of your individual opinion. Now it's your time to perform. You know how you could think about us in those days when you wanted to criticize us? We're not going to criticize you, though. We're going to just watch you work. And watching you work is what makes this country so great. Because it's 12 citizens, good and true, coming together from this community from disparate backgrounds. Experience not required. Citizenship, the only requirement. To do justice, to do right, to right some wrongs, to straighten this out. That's what we're asking you to do. To follow the law, determine the facts, and come to a well-reasoned decision. That's what's going to happen tomorrow afternoon for you. Now, it may take 1 day or 100 days, but you've been committed. I know that you'll stay the course. Keep your eye on the prize and do the right thing. Now, when I sit down this time, I won't get another chance to argue to you or discuss the inferences because it has to stop sometime. But Ms. Clark gets to talk to you later tonight or tomorrow. And I want you again to use your common sense. And remember, if she raises some point, I may not be able to get up and respond, Mr. Sheck or I. If it's something that's not purely rebuttal, you may see more objections this time because we've got to keep it in line. And I want you again to use your common sense. And remember, if she raises some point, I may not be able to get up and respond, Mr. Sheck or I. If it's something that's not purely rebuttal, you may see more objections this time because we've got to keep it in line. But if it's a point that we can't respond to, you substitute your wisdom and common sense as to any point. I think you know by this time we can answer anything that they would say. So I'm sure you'll give her the same attention you've given us today, and I wish them good luck. In fact, let me say this. In this case, we have been advocates. We have fought hard, I hope. But it's not personal. What is personal is this case. What is personal is our zeal and our desire that our client be acquitted. It's not personal against these prosecutors. in this part of our discussion, I want to share a couple of things with you and clear up a couple of things if I might. Remember, I was examining Detective Lang, and it was interesting that we saw Detective Lang here today. That's interesting, isn't it? Detective Lang was here. He's the only one who can really come anymore. We discussed the roles of these people. It's the only one who's going to show his face here, you can count on. But Lang says that early on that they had, I asked him questions about traveling around the world to investigate this case, to get an idea of what resources were they putting on this case. You remember right at the very outset, the reason that robbery homicide was put on the case was because downtown they supposedly had better resources. There's some doubt about that, but they did that, and they put resources, including everybody in the LAPD. They had the DA's office and their investigators. They've had the FBI. They've been all over the world. You know, they've been everywhere looking for Bruno Magli's shoes. They've been to Italy. They've been to many of the states in the United States. And I asked them about those things to give you a scope of what they were trying to do. And, you know, it's awesome, the power of the state. And at one point I worked as assistant district attorney, so I know about the power of the state. There's no priority to being on this side. I used to be on this side. You can be on both sides. It perhaps gives you a little different, a balanced perspective. But they have a lot of power. They can do a lot of things. They have a lot of resources. And they've used them in this case. So don't feel sorry for them. They've used every resource they had. When they didn't call people, there was a reason for it. It wasn't they didn't have the resources. These are excellent lawyers. They know the facts. If they didn't disprove something, if they couldn't disprove Henry Lee, if they didn't call anybody for John Gerdes, it's because they couldn't find anybody. Earlier, I talked to you about Detective Furman on this particular point. I wanted to make sure so we could be as accurate as possible. This question was asked by Bailey. There is a problem that has been brought to your attention, isn't there, Detective Furman? Answer, no. Question, when discussing this event in the preliminary hearing and talking about the glove, your tongue slipped and you said them, didn't you? Answer, yes. In case there was any question about what we'd said earlier. Mr. Scheck has covered the brush marks on the door, but what I'd like for you to do is look back at your notes, because Furman said that regarding these brush marks, he said he saw these marks on that door while the door of the Bronco was closed, remember? And the reason why this has become so important was he was trying to say he hadn't gotten inside. Then we called Larry Regal, who said you couldn't see the ones at the top unless the door was open. And then Furman also had said that he told Fung about these brush marks. If you look at Fung's testimony, I think you'll find that Fung never says that he heard that from Furman. And so, you know, with regard to Furman, I could have gone on and on and on about lies, but that would be counterproductive after a while, because you know who he is now. There's one other point I wanted to share with you about Furman before we take our leave of him, is that there was some questions in counsel at 18906 about opportunity for Detective Furman. Here was a series of quick questions. When you arrived at the scene this night, were you wearing a coat, a jacket of some sort? When I first arrived at the scene, yes. Can you describe it? Answer, a blue blazer. All right. And you were wearing the trousers and shirt that we see you in with your weapon in the picture pointing at the left-handed glove. Yes, tan slacks. Okay, now, at some point, did you walk back to your vehicle and take off your blazer and hang it to lay in the vehicle somewhere? Yes, sir. Okay. Can you tell the court and jury about what time of day that happened, bearing in mind that you arrived at about 2:10, that's a.m. It would be after I was relieved from the case. Now, he's relieved a short time after he gets there. He's relieved by 3 o'clock, isn't he? Before 3 o'clock. All right. That would be close to 3 o'clock? Yes, sir. Question, and that is when you walked back to the vehicle, and left the jacket, and stood waiting for your relief? Yes, sir. Now, I don't believe hardly anything he says, except that it is true that in this photograph taken at 4:30 or before sunrise, the one you saw where he's pointing at the glove, he doesn't have a jacket on. So he had a jacket, went to that car by himself. There's many things in that car. This man had ample opportunity to get up to that scene. You know, as I told you, it's so stretches the credulity to believe that so neatly placed were this knit hat and this glove. Were there two gloves at some point? When he says, I saw them, why would you say them? There weren't two gloves. And, you know, it's so unusual because everything else is spread all out. This was a vicious fight. There's a beeper over here and there's keys over there. But these items are right there, right where you can point at them. It's two packed. So you can ask yourself those questions when you go back into that jury room. Now, in this case, I discussed with you Miss Juanita Moore, a lady that I called to the stand, and I think I misspoke myself. I think I mentioned to you that, I think I may have said, she said that Mr. Simpson did not have dandruff, and if I did say that, I got that wrong. She said that Mr. Simpson would get dandruff, I think, in the off-season, in the spring and summer when he was here, as opposed to when he was in New York. And I wanted to make sure, in looking at the transcript over the lunch hour, I noted that. Ms. Clark seemed to be amazed when Mr. Scheck said that Kelly Muldorfer said that she didn't see blood in that Bronco. So to save her some time, I'm going to read you the transcript. Kelly Muldorfer at 38268, lines 26 through line 9, I think at 38269. Question, and when you looked at the console, do you remember seeing any blood there? Answer, no, I don't have any specific recollection. That's the lady, the investigator, who was looking at this. The defendant is not required to prove him or herself innocent or to prove that another person committed the crimes charged. So now, if that's what the law is, and the judge gave you that, or Mr. Darden asked the question, who did this? Who committed this crime? Why would he ask that when the judge just said, the defendant doesn't have to show anything? And we know in this case, they rushed to judgment, they didn't look at anybody else. That's a question he should be asking these detectives, not us. We're the ones who had the preeminent experts who wanted to help out. They wouldn't accept them. Could he ask us that question? How could he ask us that question in good faith? So what the answer is, you go ask your detectives. That's the answer. Now, he asked another question. He said, well, where was O.J. Simpson? He says, well, you know, how does he account for his whereabouts after 10 o'clock? Well, let me just take a minute about this. He asked that question. So let me answer it for you and for him. Some of you in your former life probably lived alone. If you lived alone, if something happened between 10 o'clock and 6 o'clock in the morning, it's real difficult, if you live alone, to prove where you were if nobody lives there with you. Isn't that true? Is that common sense? Mr. Simpson lived alone. But we've done more than that. We can establish where he was. He was at home. That Bronco was outside. He was packing and getting ready and rushing around at the last minute and coming outside to that Bronco, getting his phone, getting the paraphernalia for that phone. That's what he was doing. He was packing. He was getting the golf balls, the golf bag out of his car that was seated out there. He was packing and getting ready and rushing around at the last minute and coming outside to that Bronco, getting his phone, getting the paraphernalia for that phone. That's what he was doing. He was packing. He was getting the golf balls, the golf bag out of his car that was seated out there. He was getting golf shoes and whatever goes with golf if you're a golfer. That's what he's doing. He's getting this little knapsack out that has golf balls in it. And he was bringing another bag down, all of which were ready when Park, Cato were out there. And he comes down with the other bag, carrying it. That's what he was doing, Mr. Darden. That's where he was. It's your speculation. He's on the side of his house running into an air conditioning. That didn't happen. That's unreasonable. Nobody here believes it. It's not going to help save their case. They're speculating again. Speculating. Cynically speculating. And it's not going to work. And so that brings me to this other instruction. It's called alibi. You remember during voir dire I asked you about this. I said that you won't place a bad connotation on the term alibi. That's what the law calls it. Alibi. And it says as follows, that evidence has been received for the purpose of showing that the defendant was not present at the time and place of the commission of the alleged crime for which he is here on trial. If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed, you must find him not guilty. Can I repeat that last part for you? If after a consideration of all the evidence, you have a reasonable doubt that the defendant was present at the time the crime was committed. It doesn't say you might find him not guilty. You might think about it. It says you must find him not guilty. And so, you know, when you talk about this whole concept of reasonable doubt, and we'll talk a little more about that, it's how you feel inside about this evidence. It's how you feel inside about these messengers and their message. It's when you have that queasy feeling. You can't trust this evidence. Barry Scheck described it well as a cancer. He talked about one cockroach you don't need to see anymore, because you know if you see one, there's a lot of them around. All you need is one, and that's going to make you go the other way. In this case, you get past the, you don't have to get past the socks. But then you get to the glove and the Bronco, and you get to all of it, none of which you can trust. And then how do you do it? Do you get back there and say, well, I don't trust him on this. I think I can trust him on that. When these essential link in the chain is broken, you got reasonable doubt. And so your job won't be quite as tough as you may have thought. Reasonable doubt? In this case, the prosecution has not offered one coherent theory to explain how these deaths occurred. He came home because his little girl was having a concert. That's the kind of dad he is, and somebody has to stand up for him. People don't want you to stand up for him. People can't stand the truth, but they're going to hear truth in here. There's one place you can't take away somebody's voice, and that's in the courtroom. When you want to tell the truth. For 16 months, this man sat over here and heard people talk about him day in and day out, judged him and prejudged him against the American way. What right? How dare them do that? And he has 1 day or 2 days to have somebody stand up for him, and people are crying and moaning. It's outrageous in America. It's intolerable, if you will. And so this is a good and decent man who loves his family, loves his kids. None of us are perfect, but he's a man who went a long, long way. Raised primarily by his mother, you know what he did with his life. He had a good life, a wonderful life. He's done well. He's not going to give all that up? Try and kill somebody with a knife? He's not going to give that up. And you know what? If you think about this case, can you imagine that a man who loves his children so much is going to go over, kill his ex-wife, kill their mother, and leave her so that the children can come downstairs and find her? That defies credulity. None of you believe he would do that. It's contrary to everything that you can believe and that you've heard about this man and what he's done and what he's done with his life. So forgive me if I speak out for O.J. Simpson. If I'm so presumptuous as to believe that the Constitution means that you're presumed to be innocent until you make the decision. Nobody outside here has a vote. You have that vote, thank heaven. These narrow-minded people, thank heaven they don't have a vote. You will have the final say. The prosecution had a puzzle. And it was interesting how they did this puzzle. Technology is wonderful. And you saw they kept, under this puzzle, putting on pieces and that sort of thing. And so we thought about that. I thought about this puzzle. Thought about what it meant in this particular case. I got a call from a very, very wise lady who reminded me that if you've ever gone to the store and bought a puzzle, when you buy a puzzle, on the outside of the box of the puzzle, there's a picture. So you know what the puzzle looks like when it's finished. Well, in this case, the prosecution took a photograph or picture of O.J. Simpson first. Then they took the pieces apart. If they really wanted to talk about reasonable doubt, you don't jump to conclusions at the beginning. You don't rush to judgment and then be concerned about an obsession to win. What you do is you take the pieces and put them together, and then you come to the conclusion. They got it all backwards. It's like what they did with the Fourth Amendment. It's like asking us, where is this witness? What did you prove? Solve this crime for us. They got it all backwards. Don't you see? And so that little example, a jigsaw puzzle, was clever, but really it trivializes a man's fight for his freedom, who's always said that he was innocent from day one. So I wanted to just summarize our sense with a graphic, thanks to Mr. Bob Blazer, of this evidence, and why there's reasonable doubt as to each of these items. Please note the monitor. All right, let's look at first. We know in the upper left-hand corner there's missing blood. They can't explain it, and they went down in flames, going out with a home video where it was actually embarrassing this morning. You want a little levity during the tough times in your deliberations? Play the Thanoparatus video. In fact, it's so bizarre that if you listen to it again, you'll hear Hank Goldberg is laughing himself. He starts laughing when, if you look, the words are mouthed by Paratus. He goes like that, and Goldberg starts laughing at his next question. How embarrassing this is, but this blood is still missing. You'll have that syringe there. So, Mr. Blazer and Mr. Harris, what does that mean, that missing blood? It means reasonable doubt. Then we have the socks, my personal favorites. And when I talked to you about the socks yesterday, I may not have told you that in addition to the socks not being in the video at 4:13 on June 13th, and how they placed them there later, and how they were collected at 4:35 or between 4:30 and 4:40, Willie Ford came in here and testified to you he didn't see the socks. Forgot to tell you that yesterday. He testified they weren't there either. So thank heaven there's one person who wasn't part of that cover-up, although they got to him and he was saying things, oh, well, the socks may have been covered. But he still works over there. So we'll forgive him for that, but he didn't know what we knew about Lang and Mazzola and the time they were collected in their log. Plus the timing on the whole thing got them. And those straps on the bed further. So what have we shown you about the socks? Reasonable doubt. That moves to the back gate. What about that back gate with EDTA and more DNA than you could ever imagine, and it's picked up and collected 3 weeks afterwards when people have been all over the place, and you saw the photograph? Look at that photograph. That photograph doesn't show any blood. It shows some little tiny spot. It was totally inconsistent. They're trapped again by the video. This case will go down as the video case because we have shown you for your own eyes why they lose this case, why there is reasonable doubt. So the back gate, reasonable doubt. And then we started out with the timeline because we knew at the outset the timeline with the witnesses that they failed and refused to call establish a reasonable doubt. It shatters the prosecution case. If you start there, you'll find these witnesses credible. O.J. Simpson couldn't have committed these crimes. There's reasonable doubt. He's not guilty. The timeline. We went from there to the EAPB, and you'll remember that, and Mr. Scheck has talked about it. I won't be redundant. The double-banded B, that's somebody else. They can't explain it. They never tried to explain it, except to talk to you about something that's not in the literature. It didn't work. There's reasonable doubt about who that person was. O.J. Simpson's demeanor. All those witnesses who didn't know each other, who you heard, who they talked to, you saw them all. You think that he was acting for those people? You remember that one of the most interesting things was Mr. Darden said that when the Scott Kennedy video at the June 12th recital, where a man just happens to stop by and takes a video, Simpson doesn't even know he's being videoed. This guy doesn't know Simpson. He's taking a video. Just came to us out of the blue. They had the audacity to tell you he was on camera. You know anything about being on camera? Somebody's taking a video of you. How do you know that? But we had that video, and they have nothing else to say. You ever notice when they have nothing else to say, how they just say anything? That's an example of that. That's an example of O.J. Simpson's demeanor, and that was our answer to this so-called fuse. We had proof for you. You saw him on that date, and we took you through step by step through that date. We've already covered the EAPB, the Bundy blood drops that Mr. Scheck did such a great job on, and you know about those drops. You know the numbers as well as we do, and I won't go over those anymore. I think there's reasonable doubt based upon those, and of course you know the Bronco. How can you trust the Bronco? Chain of custody, how can you trust it? There's nothing you can trust about that Bronco and how they handle it. And then the gloves. The gloves didn't fit. The gloves didn't fit. The gloves didn't fit. Reasonable doubt. And then the why. Now, motive is not an element of the crime of murder, but absence of motive would tend to establish innocence. That's why Mr. Darden went to such a long and exhaustive study. And I've shared with you the fact that there is no motive in this case, but I just want to briefly tell you this about their theory at the end. If you believe what the prosecutors want you to believe, you have to believe that O.J. Simpson, who has a limo driver coming, I guess around 10:30, 10:40, after he goes and gets a hamburger at McDonald's, after having been worried about change because he had $100 bills,